we've talked about this before. This is a cop from Nevada, and he's talking about like in Nevada, we can't really arrest people for shoplifting for petty larceny unless there's something else going on, like they're not identifying themselves, or the crime will continue. Like they're like, yep, right when I leave this one, I'm going to Walmart and steal more stuff there too. And so you got to kind of let them go. But what if they have that shoplifting evidence in their backpack? Can we do a limited search for that shoplifting evidence before we kick them loose with their citation?
Yes.
Why?
Different justifications. You're saying they're in Nevada?
Yeah, they're in Nevada, yeah.
Well, I know there's the Iowa case law that says you can do, a limited search of the person as long as it's under arrest-like circumstances and they know what's happening and it's a limited intrusion.
Limited, yeah.
But there's some California case law that deals with the same thing. There's some Colorado case law that deals with the same thing, that says if you have if you have like a statute that says this is not an arrestable offense, well, then that takes away a very valuable tool for law enforcement. And so in those circumstances where your statute actually dictates you will not take this person into custody, it allows such a limited search. And then ultimately you can make the exigency argument if you have nothing, from lower court that supports you based on where you are, that if they are released, they will go and destroy that evidence. And
No, I disagree. I just think that the way you handle it, don't search them, cite them for the offense, and just tell the prosecutor, hey, by the way, when you bring them to court, give them a subpoena ducis tecum, right? To bring in that stolen merchandise. Isn't that the way we handle this? The reason I bring that up is because I saw a case or some kind of journal article about that. Like you can't, like you're never gonna see that stolen sweater again. Like you give them a ducis tecum, like they're never like, which is they're being funny, right? Like just give them a ducis tecum, which is for those people who are watching. That is a subpoena that tells a witness, I guess a defendant, to bring in, you can do it for defendants, to bring in certain things with them, right? Unless they incriminate themselves. But the thing is, like, it's kind of funny because obviously you're never going to see that stolen merchandise again. So yes, you grab it and go, but it is a limited search. You agree, Zach?
Yes. Yeah. Yeah.
The Ninth Circuit.
I could elaborate, but you want to keep these brief. So yes.
Yeah. Let's keep them brief. So, but one thing, the cop did ask for a citation out of the Ninth Circuit. There is a case called U.S. versus SNIPE, SNIPE, which talks about recovering marijuana when California was a cite and release state for marijuana, and the court upheld the grabbing the marijuana and kicking the guy loose. So I don't know why shoplifting is any different. All right.